argument between the judges and, in fact, between Biosig itself went to the scope of the claim. Namely, does the scope of the claim cover all ways of achieving the desired result, no matter how the electrodes are spaced? That's one possible reading. The other possible reading is that the claims cover only a special spacing of the electrodes to achieve the desired result. And why that matters is if you think of the inventor in 1994 who invents a new material for electrodes, and this new material achieves the desired result of detecting equal muscle signals on the left and right side, regardless of the spacing of the electrodes. So it doesn't matter where you put the electrodes, as long as you can touch them. This new material achieved the desired goal. That inventor would not know in 1994 if they infringed or not, because if the claims had the interpretation that the majority eventually gave them, namely that the spaced relationship has this functional limitation and it must be the result of this trial and error balancing, there'd be no infringement. But if spaced relationship meant any spacing, then there would be infringement. So that is the exact type of zone of uncertainty that United Carbon warned against and which deters the innovation.
The working here is that it cancels out a signal, correct?
Yes.
And so what the majority said is that that function is part of the understanding of the spacing. Isn't that what the majority said?
It said that an additional constraint on the spacing is the fact that it will work in a certain way.
So I don't know whether it has to be equal spacing or one could be 1 inch and the other half an inch apart. The bottom line is that to work, it has to cancel out. That's part of the scope.
Yes, yes.
Now, the concurrence said, no, you can't, I'm not looking at the specification.
Yes.
I think it's definite without it.
Yes.
All right? I don't see how it could be. That's what I think Justice Scalia is saying and Justice Breyer is saying, that if we don't understand what the purpose is, how can that spacing be definite enough to make this thing work? So tell us why you think that the concurrence's interpretation is wrong. What's he missing?
When it says whereby means the elements that came before are going to produce that result.
Mm-hmm.
There's never been a problem with the fact that some amount of experimentation, I hate to even call it that because it's really just tuning dials on a radio, may be needed in order to get the exact number, the exact
result
setting.
That the specification.
But what the whereby clause says, it conveys a structure. It says they have to be detected, the signals, in such a way that they're equal. That normally wouldn't be the case. In all the devices that existed up to that time, they wouldn't be equal. Signals would come in from the right and left hand that during exercise would be unequal because when a person's running or moving, the right hand and left hand have different amounts of contact with the electrodes. The whole novelty of this was the fact that you didn't have to cancel EMG signals, what we call downstream, meaning by just filtering them out. They could be detected in such a way that they would be equal and then be canceled.
We have in mind this reasonable person and a set of circumstances in which the reasonable person is going to act. So in torts, the reasonable person is going to engage in an activity that has some benefits but also has some risks. What would that person do in that situation? Now, here you're saying what would the reasonable, skilled artisan do in what situation? What is this person doing? Setting out to build the device? What?
They're trying to understand the scope of the claim. So I do think it's important here to recognize that there are two different questions that are getting conflated in some of the discussion. I think that with respect to definiteness under paragraph 2, as the Court of Appeals majority recognized, that this is, in this case, the question is whether the claim clearly states that it requires the electrodes to be arranged in such a fashion that they will have the effect of detecting substantially equal EMG signals at the electrodes. It's not with downstream circuitry, which is what Petitioner suggested in the opening brief. In Petitioner's reply brief, they've suggested that they could use some sort of protective sleeve on the electrodes, but that wouldn't be consistent with the parts of the limitations that say that there needs to be physical and electrical contact with the electrodes. And the majority recognize that there are multiple variables that come into play here, the spacing, the materials, the separation, as my co-counsel was just explaining. But the disagreement between the majority and the concurring opinion here is just in whether the functional limitation inheres in the phrase spaced relationship taken in isolation or whether it can be read from the rest of the claim as a whole.
Would you say something?
Do you agree that the standard at the PTO, and let's say that it's whether or not the claim is definite if a person skilled in the art would be reasonably certain of its scope, is the standard used by the PTO the same standard that the CA Fed ought to use?
Yes, it is, Your Honor.
All right. How does that's a sensible answer, I think. Now, how does the presumption of validity bear on the application of that same standard in the Court of Appeals?
The presumption of validity certainly applies to this defense. It requires the challenger to raise the defense, to preserve the defense, plead it as affirmative defense, to make the initial argument as to why the claim is
Doesn't
definite.
it imply some deference on findings of fact?
Your Honor, it would be rare for there to be, in an indefiniteness case, to be any underlying finding of fact. The issue of indefiniteness is really subsidiary.
What does it imply? What sort of deference does it accord to the PTO?
If indeed
that is the presumption of validity, does that accord some deference to the PTO, and how would that apply or not apply here?
It would apply. It does not apply in this case. There are no fact findings out of the Patent Office regarding indefiniteness. But if there was the same indefinite issue came up, and the Patent Office found, for instance, that a term of art, so let's say nanotechnology, biotechnology, term of art had a particular meaning, then that fact finding may be entitled to deference by the trial court. However, indefiniteness itself is a legal determination. The Federal Circuit said that. They review this. They know.
So there's no deference to the PTO as to that legal interpretation?
No, Your Honor, no more than that.
Occurrence's definition is different from the majority's. The government explain. I read your brief. I know what you think the difference is, but
between the majority and the concurrence below. First, we don't think
he says there's a difference in scope. So address that.
Yes.
Why don't you see that as being a difference of importance?
It would be a difference if there were a difference in scope, but there isn't one. I think it's very important to look at what the majority and the concurrence actually did. The majority was addressing definiteness. The majority did that in two steps. The majority said we're going to apply the principles of claim construction. The first thing it did was it looked to the claim language, the written specification, the diagrams, all the traditional tools of patent interpretation. It said there's definiteness here because there are bounds to this spaced relationship. It isn't just anything. It has to be greater than 0. It has to be less than the width of a hand. It's implicit and actually explicit in the statement of the patent. Then it said that the functional limitation, which is the whereby clause in the patent, sheds additional light. That's where the concurrence got off the train. And the concurrence said, I don't think we need to reach that issue. Nautilus has turned that approach on its head. Nautilus says that the fact that the concurrence didn't think it was necessary to reach the functional limitation, in fact, said that it's not before us for procedural reasons. Nautilus reads that as if the concurrence was somehow disavowing or disclaiming the majority's approach. It never said that. It was a procedural argument that it had.
It seems to say that if there's two reasonable constructions and one would make the patent valid. I think this goes to Justice Kennedy's question, that they're obligated to pick the one that makes the patent valid.
The case, I believe the case that's being talked about there is cited in the Exxon opinion, and that talks about when there are two equally plausible constructions. I think that probably is the knife edge of insolubly ambiguous. And there, the Federal Circuit suggested that as Justice Scalia was saying before, that because there would be a decision rule that you would pick the construction that would save the patent.
Is that right?
Would be okay. I don't think that allows for sufficient clarity. We believe that if there are
so they're
two
wrong in
constructions,
that as well.
In that particular statement of the rule, yes. We do think, however, that there is a distinction between the presumption of patent validity does play a role here. It doesn't change the standard, but it does play a role in indicating that, as the PTO has recognized, that courts will do more to save a patent than the PTO does when it's examining one.